Good afternoon. You can be seated. The matter before the court is Chockstone Group, LLC versus Robert Martin et al. This is Somerset 23483. We are being streamed live on the web, both by audio and visual. And I would ask counsel to introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Joshua Dunlap, representing Robert Martin and Charlotte Fawcett.
Good afternoon, Your Honors. I'm Judy Metcalf for the appellees, which are members of the child's family.
Thank you. Counsel, if you're ready to begin, we'd be happy to hear your argument.
May it please the court. This appeal presents a question of first impression. Can a user obtain a prescriptive easement over a road even though, 1, the road's owner imposed maintenance fees, and 2, the user paid the fees upon demand? The relevant facts are not in dispute. The Martin family over the course of a decade charged fees to the Child's family relating to Wildwood Lane. The Child's family in turn paid those fees when asked. On these facts, the prescriptive easement claim fails as a matter of law. The Child's family cannot carry their burden to prove both acquiescence and adversity. First, the Child's family cannot prove acquiescence by the owner. To prove acquiescence, the Child's family must prove, quote, consent by silence, that is, and quoting again, passive assent or submission to the use. In charging fees to the Child's family and others, the Martin family exercised active dominion over their property. Thus, having imposed fees relating to the road, the Martin family did not passively submit to the Child's family's use. Second, the Child's family cannot prove adversity. To prove adversity, the Child's family must show that their use of the road, quote, disregarded the owner's claims entirely. In paying fees when asked, the Child's family acted in subordination to the Martin family's rights. They did not disregard the Martin family's claims entirely, as though they owned the road themselves. It does not matter for purposes of this analysis that the Superior Court concluded that the fees were for maintenance. There is no basis in Maine law for distinguishing between so-called use fees and maintenance fees in determining whether the owner passively submitted to a use or whether the user disregarded the owner's claims entirely. Accordingly, the Superior Court's judgment cannot be sustained. Given the periodic payments by the Child's family, they cannot establish an uninterrupted 20-year period of use. Judgment should enter for Robert Martin and Charlotte Fawcett. I'd be happy to answer the court's questions.
Counsel, my understanding is that in terms of owning the fee of where Wildwood Lane is, that was not actually established or clearly established until 2006, correct?
There was a dispute over that.
Okay. So, and I understand your clients may have thought it was clear all along, but apparently somebody didn't think so, right?
Correct.
So, in terms of those factors of adversity and the like, if you're charging a fee before then, and it's not even clear that they're the owner, doesn't that really go to the idea that it is actually a maintenance and not an access fee?
No, Your Honor, and that is because there is no record evidence that the Child's family ever requested that the Martin family provide any services on their behalf.
Any what?
Any services on their behalf.
Okay, but I mean, but you're talking about it in terms of adversity to the true owner and acquiescence by the true owner. And prior to 2006, it wasn't clear that the Martins were the true owner.
But they were acting as the owner, and it is certainly
from your client's
not been,
perspective, I don't know if that's true from everybody.
Well, it has certainly not been established that they were not the true owner. It was ultimately settled, the deeds were clarified, but my client certainly has maintained the position that they have always possessed Wildwood Lane. And the important thing for purposes of this case is they acted in accordance with their assertion of rights throughout the record period here.
There was a time when Childs didn't pay the fee in the history of their use. Is that correct?
There have been interruptions, but nothing beyond 20 years, Your Honor. So,
but I'll just ask you, during periods when the Childs didn't pay the fee, whatever it was for, was their access across the road stopped?
There was dispute over that, Your Honor. Ultimately, the Superior Court found that prior to 1997, were not necessarily precluded from using the lane. But the important thing is that there was never any 20-year period of use in which they did not pay a fee to the Martin family.
Are you arguing that a payment for maintenance as a matter of law, or for, I guess, either maintenance or access, doesn't matter, precludes a finding of acquiescence or adversity? It seemed to be that you were saying the fact that they're making a payment, whether it's for maintenance or for use, precludes as a matter of law a finding of adversity or acquiescence?
That is correct, Your Honor. And that's because, again, collection of fees is inconsistent with passivity or submission, which is necessary for a showing of acquiescence. It's likewise, there's a demonstration of subordination.
If they didn't ask permission to travel over the road, to the extent that they traveled over the road, the payment of a fee to maintain the road could be characterized in a different way, could it not?
Well, it could be characterized in a different way, but two things are important to remember. First, this court has said that implied permission prevents a finding of adversity. So there doesn't have to be an express statement of permission, and that's very, very important. Second, it is also important to remember that the child's family bore the burden of proof in this case. So if...
Well, that's the question. Is it a fact? That's what I'm trying to get out of you. Is it a fact question, or is it a question of law?
Well, it is a question of law, and the facts as proven, there was no evidence whatsoever that the child's family ever asked the Martin family to provide them a service. So the way that I would illustrate it is this way. If a reasonable person believed that they had ownership rights over a road, and a person approached them and demanded payment for services rendered, that a reasonable person asserting ownership would decline to make payment because they believe that they own the road. If, however, somebody approached them whom they believed had superior rights to their own, and they demanded payment, and in turn they were paid that sum, that indicates that the person who paid those fees recognized.
I'm going to challenge you a little bit on that. Let's just, certainly in the case, if it had been a deeded right-of-way, and the subservient estate owner, you're traveling along a whole large distance, we've seen the maps, over the subservient estate, and said, you know what, I want you to pay me so I can maintain the road because you're using it too. And the dominant estate, or the person who has the easement, says, okay. I mean, I understand, we're taking it out of the adverse possession, but I mean, there's nothing inherently inconsistent with the idea of paying the person who frankly owns most of the length of the road for maintenance.
Well, what we have in this case, Your Honor, is the owner of the road demanding payment in return for the use of the road to pay for the additional maintenance that it would take caused by the wear and tear of the person traveling over their road.
Well, again, counsel, that's your...
What you just said, though, for use of the road, is that in the record? Is there record evidence that it was put to the child's family in those terms?
I may not have framed that in the best way, Your Honor. What is shown here is that a payment of maintenance fees, because the Superior Court concluded that it was for maintenance, not for use.
And you're agreeing that's a fact question?
Pardon?
You're agreeing that aspect of it is a fact question?
Yes, we are.
Okay.
That's correct. But accepting that that was a fact question that the Superior Court determined, the question now before the court is a question of law. Does the payment of maintenance fees, is that consistent with either acquiescence or adversity?
Why
and we say
can't
no.
two things be true at once? That the child's family is voluntarily willing to pay the maintenance fee, and there's no dispute as to their right to use the road.
Because, Your Honor, we should view this through the precise language that this court has used for both acquiescence and adversity. And for acquiescence, there has to be passivity or submission.
But we've never viewed it in this context.
That's correct. It's never been viewed in this context. So it's a question of first impression before this court. But what I would submit to the court is that you are not being passive if you go to a user of your road and request payment of maintenance fees. It's important to recollect, Your Honor, that this is a rule set for lay people. A neighbor does not necessarily speak in legalese to their neighbor when there's a discussion regarding the use of a road. Instead, informal conversations occur, and those informal conversations could consist of, pay me some additional money because it's going to cost me more to maintain this road.
Or
And
the conversation could be, hey, would you mind, you know, you guys use the road, we have no problem with that. Would you mind chipping in to help out, help maintain it?
that may also be, but what is known here is that the Martin family went to the Childs family. They demanded payment. That was found by the Superior Court, and the Superior Court also found that the Childs family made payments. And so that is an assertion of
But is there any
control.
evidence in the record here that Martin or one of the owners said to Childs, well before the litigation here, you can't use this road unless you pay this fee? I'm looking through the record here. I couldn't find anything quite as blunt or as clear as that.
It was a disputed fact, Your Honor, and ultimately the Superior Court found that it was for payment of maintenance fees. It was not expressly stated that there was permission granted.
So there is no, we don't start with the assumption that that statement was made.
That is correct.
Okay, but doesn't that take us to acquiescence?
We should be looking at acquiescence, and there was no acquiescence because they demanded payment, and they received payment. And under those circumstances.
So does this then turn on whether it's a question of law or fact? I mean, I think I got you down on we agree that the conclusion that it was for maintenance is a fact question.
Correct.
But that your position, and you've already said this, is that a payment for maintenance, as a matter of law, precludes a finding of acquiescence or adversity.
Correct.
If we say that's not a legal question, but rather a factual question, do you lose because there's evidence supporting what the judge concluded?
Well, coming to that conclusion, Your Honor, would be inconsistent with Lyons, which said that it's a question of law to determine what acts of dominion constitute an assertion of adversity. And so the court has already determined that this is a question of law, not a fact.
Why isn't the existence of a, quote, road maintenance agreement as consistent with an agreement among co-owners of a road, one of whom is maintaining the road, the other is paying to maintain it, as it is with permissive use?
The Superior Court certainly found that the 2006 road maintenance agreement supported a finding that it was a permissive use. It was for both maintenance and access, and so the court said that there could be no demonstration.
Oh, it could be, I agree, but it's, I thought your position was paying for maintenance means that it's permissive, per se.
That is correct, Your Honor, and then that was ultimately recorded in the 2006 road agreement.
The court in paragraph 57 of its findings said, and I quote, "The court does not credit defendant's account of the purpose of the fees prior to the execution of the maintenance agreement," end of quote, prior to the execution in 2006. May I
Yes.
continue?
You may,
Okay.
and you actually get to have a brief answer since he's
Thank you, Your Honor. Well,
in the
certainly,
intersection.
the court did find that the 2006 agreement indicated permissiveness. It had found that prior to that, the road maintenance fees were in fact for maintenance rather than for use. But what we submit, Your Honor, is that that distinction is not a distinction that is supported in Maine law. There are 0 cases that support that conclusion.
Thank you.
Thank you.
And Attorney Metcalf.
Good afternoon, Your Honors. My name is Judy Metcalf, and I'm here for the Childs family. This family has accessed this tiny camp on their postage stamp parcel in St. Albans for over 100 years. The evidence was clear that they accessed that camp via the road, a picture of which you have in our brief. There was never any dispute as to the location of the road, never a dispute as to the width of the road, never a dispute as to continuity. Indeed, as the court noted, we had clearly established that we used the road from 1947 on, and that the Martin family hadn't even come into the area and been aware of their use until 1952. As the court noted, the question here, which he just characterized as fervently disputed, was the question of acquiescence. That is a question that is dependent upon a standard of review of clear error. We must give deference to the court which heard the witnesses, saw their poise, heard their evidence. This is not a new question of law to be decided on a flip the coin. You pay a fee, you don't pay a fee. There is a prescriptive easement, there isn't a prescriptive easement. As Justice Horton just noted, in paragraph 57 of the substantial findings here, the judge found that there was no evidence that they had either granted express permission or attempted to deny access at any time prior to the 2006 circumstances, which I'll get to in a moment. The court specifically found that as a matter of law, acquiescence had been found for the 20 years prior to 1997. In fact, he says at least 20 years. And we all know that once an easement by prescription is created, it is as good as an easement by deed. So the question in 1997 is, do we have an easement? The judge found we did by acquiescence, by silent assent. You've heard that perhaps payments over the years ought to have suspended or taken away that right, start a clock setting again. So let's talk a little bit about what the evidence was of payment. The evidence that was of payment for the years prior to 1997 were 3 entries, 60, 61, 62, child's family, road fees, $2.50.
From 1952 to 1997.
Right. There are also 2 canceled checks or a cash disbursement statement in the 80s. I don't want you to think that I'm not. So, but by then, we already had our 20 years. The 60s to 84, the court found we had a prescriptive easement by 1997. You can't take that away once you have it in existence. But the evidence was clear that any time fees were paid, they were paid for maintenance. You've just heard counsel for the appellant say that we don't know from the Childs family why they paid it, if they requested maintenance. Mr. Jeffrey Childs testified, Robert had a tractor. He graded the road. There was evidence as to the purpose of it. And you're absolutely right, Your Honor, that there was substantial evidence that the Martin family didn't even own a portion of the road that they were maintaining until 2006. They received a deed to that in 2006.
If an owner says to a prescriptive easement holder or prospective easement holder that you have to pay maintenance fees, we keep up the road, and if you don't, you can't use this road, what would be the legal result of that?
That's a different question than what was presented here.
Understood. I'm just trying to nail down the rules of law that govern us here.
I think that the rule of law would be that we have to consider the facts in the context of the evidence.
Sure.
The Jacobs versus Boomer case, which is relied upon by appellants to ask you to create a brand new rule of law, is specifically determined on a clear error basis. My language a moment ago about the trial judge having the best opportunity to evaluate the poise and credibility of witnesses is from Jacobs versus Boomer. So to go to your question.
Yeah, my hypothetical question.
You must give me money if you want to use this road.
Even though I'm calling it a maintenance fee?
Right, even if I'm calling it a maintenance fee.
Okay, all right.
That's a totally different case, and I would suggest that if the evidence was that he said those precise words, that may strip you of your prescriptive easement claim.
Okay.
Because it's conditional use. The difference here is we don't have any of that in this case. When there finally is a maintenance agreement that is created in 2006, after the deed from the Schultz family to Mr. Martin, Robert Martin, we have Jeffrey Childs testifying, well, I want to make sure the gate he just put up stays open, as the cable had always been, and I want to make sure he maintains the road. And you've read my brief, so you saw the summary of the evidence of the judge's examination of Mr. Robert Martin about that maintenance agreement.
There's a sentence in the road maintenance agreement that reads, quote, "In return for such payment by the Childs, Wildwood agrees to maintain a passable road and provide access through any chain or gate." If there was already a right to access as of that date, why did the agreement need to say that access would be provided?
Mr. Jeffrey Childs testified that he didn't want to have the type of contretemps that other people in the neighborhood had had. He was mindful that the Schultz situation had finally been resolved, and he didn't want to be involved in something else. As the court noted, that solved the problem for the families for 10 years. It defined what they were willing to do. It expired. The junk car that you've all seen in the photographs lands in front of the gate. For emergencies, call this number. This action was started as a result because we knew we had the rights. And the court found that as of 1997, we had acquired a prescriptive easement.
So again, your
Counsel,
position is
can I
that...
ask you about the historic record of the payments here? I'm looking at the exhibits that, I'm looking at some of the pages that are in the appendix. They go back to 1952.
Correct.
And starting in 1952, there are ledger entries here for fee charged for private road, $28.50. Fee for road use, $41.50. Fees for private road use, $57 in 1954. I thought I heard you say earlier that the court had only found that the Childs were paying in several years in the 60s. So these ledger entries don't reflect transactions with the Childs family.
We don't know who paid the fees that you've just referenced.
But they do.
We know they don't say Childs family.
But they do suggest that at least the Martins were thinking of this in terms of something more than just a maintenance fee, don't they? They're calling it a private road. They're referring to use as opposed to maintenance. Doesn't that sort of shed a light on how the Martins might have been thinking about this?
And the Martin family had an opportunity to enter evidence as to that, to offer evidence, and the court, in the light of the evidence that was presented, found that there was no competent evidence that the defendants or their predecessors were either granted express permission or attempted to deny access. So the evidence led the court to the conclusion that they were not, they hadn't presented, as he said, credible evidence.
Well, the court made a
as to that.
finding, but is it consistent with the evidence? This was in evidence at the
This was in evidence, Your Honor, and it the court found that prior to 1997, there was not evidence of any quid pro quo use for fee. He found that in his paragraph. So this is important, and I noted this in my brief. If the appellants had thought that the court had overlooked or not paid attention to some evidence, they could have done a motion for additional findings of fact. They did not. So they have the record, and as you know better than I, you're allowed to conclude that that when the judge made the decision, he was relying upon the inferences he drew from the evidence that he put into his findings. Same situation was in the Jacobs v. Boomer case, which the appellants rely on in suggesting that a new rule of law should be created. In that case, the question was, were the fees for use or were they for something else?
What, if anything, should we put upon the testimony of Charlotte Fawcett, who was allegedly the head honcho, who said she had no information about the purpose of the fees? She didn't charge the fees, didn't know who paid them and to whom, and our only concern was we don't want to maintain the road anymore.
Right, and
what significance does that have?
Well, that's significant in suggesting that the judge heard that and concluded that the fees must not have been for use. He concluded that it was a maintenance fee. In particular, the evidence was very clear that after 2016, Mrs. Fawcett did say, we just don't want to maintain anymore. We're shutting down the camps. We don't want to do it. And as we were very clear at the trial, we're not asking you to maintain it anymore. We get it. You don't want to do it. But you can't cut us off. We own this road. We own the right to use the road. We've been doing it for over 100 years. In the Jacobs case, the court found that there had not been a prescriptive easement proven by virtue of a payment paid to use the landing area. But that was premised upon the facts, not a rule of law.
Does Mr. Martin's deposition shed any light on this? And is that deposition subject to the ancient documents exception?
Well, we spend a lot of time on that in the briefs, Your Honor, and my answer is no. It is not an ancient document that is exempt from the rules of hearsay. It requires us to look at the prior testimony rules, which is the rule under which the judge barred the introduction of that 20-year-old deposition. He found that under Rule 804, the deposition was not admissible. My clients were not parties to the case. They were not in privity with anyone in that case. They never had an opportunity.
You're essentially arguing that the more specific rule governs over the more general rule about ancient documents.
They are arguing that.
The judge is finding that essentially the restrictions on the use of the deposition contained in Rule 804 essentially mean it's not trustworthy as we would use that under 803.16.
As we argued in our brief, or I still say we when I'm all by myself.
Can I take you back briefly to Justice Douglas's prior question with respect to the payments in the 1950s? Mm-hmm. I just want to understand, you're suggesting that those payments did not vitiate the prescriptive period because A, they weren't made, you're not sure whether or not they were made for maintenance or for access, or because it's not clear who they were made by?
I think it's all the above. There was not competent evidence as to, other than the 3 years I told you, 60, 61, 62, referencing Childs, and other than those 3 years, what were they for? To go back to this question over here, maybe Russell Martin might have shed light on that in his deposition, but we wouldn't have been there to probe. We cannot evaluate the trustworthiness of the prior sworn testimony without having a chance to ask the questions. The appellants didn't even cite Rule 804 in their first brief. The judge did. The standard of review as to his exclusion of that testimony is an abuse of discretion standard. And given the hearsay and hearsay rules, which require us to marry lots of information together, there is no clear error that excluding a deposition at which the appellants and no one in privity were at the table was an error. We could not ask Russell Martin what he might or might not have meant by a conclusory statement. We weren't there. In the same way that you are challenged right now with the question, what were the fees for? You're asking us. The judge had that opportunity to find out from the witnesses what they all said it was for in this case. And he concluded that acquiescence had been proven as of 1997. He concluded that the actions thereafter were for maintenance, but by then they already had their prescriptive easement. I did have one apology I wanted to make to the court. I did make an error in my brief. I mentioned a shovel incident. I cited a shovel incident with Mr. Russell Martin. There was another shovel incident with Mr. Robert Martin. When I did my cite, I did it wrong. It's page 212 of the trial transcript. Thank you.
Thank you. Counsel, I'd like to go to the issue of the deposition, and let me ask you this. Even if we were to find that it was an abuse of discretion or error to exclude it, don't you have to show that there's prejudice?
Yes.
And the deposition's not in the record.
The deposition was proffered. The deposition is Exhibit 25.
But
It was taken under consideration by the trial court and reviewed, so it was properly considered, and there was
But
certainly prejudice.
none of it's in the appendix, is what I would say.
It's not in the appendix, but it is clearly before this court to consider. We quote from it extensively in our brief, and I would make two very important points because it clarifies critical issues here. First, the deponent testified that the fees were for use, which is obviously a critical issue that was debated long and hard, and he was an individual who kept the ledgers, for which there's now dispute over whether or not the child's paid throughout the 1950s. He importantly testified that the child's paid for more than 1 year, that they paid consistently throughout that period of time. And importantly, he also testified that they were given permission to use the road. So when opposing counsel suggests that there is no evidence that there was express permission given, that depends on this deposition being excluded. And if the deposition is not excluded, we have precisely the situation which Justice Mead questioned about, which is, what if somebody said, you have to pay maintenance fees in order to use the road? So this is a critical piece of evidence that was wrongfully excluded. And I would note also, returning again to Justice Mead's question, that it was very helpful to clarify that had there been express permission given, opposing counsel concedes that that would have defeated the prescriptive easement claim. But importantly, the law says that express permission is not the only way that you can grant permission. It can be implied permission, and that is under Almeida. So counsel's concession, I suggest, Your Honor, gives the case away, because the requirement that they pay maintenance fees is implied permission. A landowner does not have to engage in legal lease and say, you are expressly permitted to use this road if. It is permitted that they have a more informal conversation, and that's precisely what happened here.
When you say the deposition was erroneously excluded, though, you're saying that it should have come in as an ancient document?
It should have come in as an ancient document, and because of this, there's no dispute.
But didn't the court provide a rationale as to why, even under the ancient document rule, that it would not have been appropriate to admit the deposition transcript?
Well, the court made a mistake, and it believed that it had to assess trustworthiness at the outset. That is what 803.16 sets as a blanket rule, that the court presumes that it is trustworthy and can be admitted if it is over, may I finish the answer?
You may.
If it is over 20 years old and if authenticity is not disputed. Then it is admitted, and then it is permitted to then impeach that evidence. And opposing counsel has conceded that there was no trustworthiness question here because the child's family was not involved in that litigation. Thank you very much.
Thank you. Thank you, counsel. Thank you for your arguments here today. We will, as is our usual practice, take the matter under advisement and issue a written decision in due course. And with that, we'll be in recess on this matter.
All rise.